Good afternoon. This is Judge Alyssa Perez presiding over the 210th District Court criminal docket for June 14th, 2022. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our first case, please?
Yes, Judge, on page 6, top of page 6, in cause number 2022-0D01688, State of Texas versus Fabian Divicio Guerrero. Announcement of council, please.
Roa King for the state of Texas.
No.
Good
That's
afternoon.
Mr. Vaughn.
Yeah, that's Mr. Vaughn. We need to start with, I believe, yeah, Mr. Vaughn is there. So let's start with that one, please, and then we can go to Mr. Gandara. Is that Mr. Vaughn?
Yes, ma'am.
Yes, Judge.
Okay, all right. Let's go to Vaughn. Thank you, Erica. I'll call it. Calling cause number 2021-0D01580, State of Texas versus Phil Vaughn. May I have announcements, please?
Roa King for the state of Texas.
Good afternoon, Your Honor. Joshua Spence on behalf of Mr. Vaughn. Your Honor, I did receive plea papers from Ms. King today. I know we're set, I believe, for Friday. I'm going to talk to Mr. Vaughn today. I don't know if he's going to, if it's something, I know today's a deadline, but Judge, we're not ready for trial, but I think we're going to be able to resolve this case, Judge.
So what I would like to do is go ahead and if it's an offer, what is the rec, Ms. King?
Your Honor, it's ATDC.
Okay, because we are set for trial, I know this is one where we've had at least one motion for continuance by the defense. Client is in custody, has been in custody, and I know Mr. Spencer, you came in at least somewhere at the beginning of the year, more or less.
Yeah, I'm the second order, Judge.
And I know Mr. Vaughn is anxious to resolve this matter. So what we are going to do is we are going to transport Mr. Vaughn on Thursday, and this will be it will be a continuation of today's hearing. Mr. Vaughn is set for trial, sir. You are set for trial this Friday. And so it seems like the state may have communicated something to your attorney, and he's going to need to discuss it with you. The court is going to help facilitate that getting done quickly. And so how does 11, Myrna, how does 11 o'clock look, or for Thursday? Do we have, I've been putting a lot of in-person things lately, so I just want to make sure we can do it.
There's a few starting at 10:30, Judge, and they're in person, but there's time at 11 if you like that.
Okay. Mr. Spencer, we'll see you at 11 a.m. Mr. Marufo will have to arrange for transport for Mr. Vaughn to the court. If you anticipate that that will not be disposing of the case, Mr. Spencer, please have any motions prepared for the court to hear on that date, okay?
Yes, Your Honor.
All righty, thank you. Thank you, Mr. Vaughn. We'll see you on Thursday.
Thank you.
Okay. Next.
And next, may we have Guerrero Fabian?
Yes, sir.
In cause number 2022-0D01688, State of Texas versus Fabian Guerrero. Announcement of council, please.
Roa King for the state of Texas.
I'm the Gandara for Fabian Guerrero. Yeah, we're ready.
And Mr. Guerrero is appearing, you do see him, Mr. Gandara, you recognize your client appearing from the jail annex?
Yes, Your Honor.
Okay, so this was a continuation of the bond hearing from last week. I believe there were some additional inquiries on the treatment plan, placement, things of that nature. I received on Friday an email from, I believe it was from you, Mr. Gandara.
Yes, Your Honor.
I know Ms. King had some questions as well. Are you okay with me forwarding that to Ms. King?
Yes, Your Honor, I am, and I think I copied her on it.
Okay. I'll just go ahead and send it. I didn't check who received it. So in this, the email It has the letter of, well, it references a letter of participation in Project Chance, which we discussed last time. Set to release to the case manager. He's going to look for placement at, it says here, the rescue mission. I thought we had talked about the Opportunity Center at the last hearing, but through there, with the case manager's help, they're going to link him to services, helping the client with job search, EHN treatment, and substance abuse coaching. I don't recall that being, was that an issue, Mr. Gandara?
I don't think that there was an issue about it. The additional detail that I sent also, I don't remember what day I sent it was, but simply all they need to know at the reentry program is when he's going to be released, so they can coordinate and get him transported directly to the housing from the time he's released.
Okay, did we have any confirmation? I think there might have been some issues. Let me double check. Carla, do you recall what I sent you regarding issues? It was either was it the rescue mission? Yes.
Yes,
See,
Your Honor.
It so happens, and I'm just saying this, Mr. Gandara, because the email says that they're going to place him at the rescue mission. My understanding is, at least as of late last week, rescue mission doesn't seem to be taking folks in, and so I don't want that to be a problem here.
They had indicated early on that they would go to the Opportunity Center, but I can sure get that cleared up. I can get on the phone with the reentry people and clear that up one way or the other. In other words, I understand that we don't want to just release him and not have any place for him to go.
Right. Okay, Ms. King, I don't know. I know it's kind of quick turnaround here. I don't know if you've been able to see the email. Do you have any concerns or questions?
I did see the email, Your Honor. I don't have any concerns.
Okay. I want to clear that up, Mr. Gandara. I just want to make sure we have the accurate placement so that the bond order will reflect to whom he is to be released and where he will be going.
Would it be appropriate? Of course, I'll double check and then get back if I can this afternoon, if not first thing tomorrow morning. But for the bond order to state released to the reentry people, to the caseworker there.
Sure, absolutely. And so, does it have to be to the specific person? Do we know that person, or was that going to change?
I think that will change. That's why. So I want to call the current caseworker and ask her who's going to be assigned to his case once he's released, and that'll be the person to release him to, I believe.
As soon as I receive that information, then I am going to grant your request for a full PR bond with the restrictions, the conditions to be that he report weekly, obviously participate and be compliant in every sense with all of that reentry, any mental health treatment plan. He'll be subject to urine and breath analysis. He is to commit no new offenses. He is to possess no weapons. May not change, obviously, place of residence or leave El Paso County without court permission. Not come within. Do we know the proximity of his? Well, no, he'll be at the opportunity or rescue mission. So not come within or no contact with the complainants, the alleged complainants in the case.
Yeah, exactly, Your Honor. No, and it's if I remember right, this was out on the west side, but pretty good distance downtown.
Okay. Sounds good. Yeah, Marissa, if you will prepare the bond order, and I'll wait for you, Mr. Gandara, to give me the specific details, and I'll add that to the bond order. As soon as we get that completed, I'll go ahead and sign off on it.
Thank you, Your Honor. I appreciate it, and I'll be on it right away.
Thank you very much. Thank you, Mr. Guerrero. All right. Take care, Mr. Gandara.
Thank you. May I go?
Yes, sir.
Thank you, Your
Who's
Honor.
next?
All right.
And next, may we have Daniel Valles on page 9, Judge?
All right, go ahead, please.
Cause number 2019-0D04292, State of Texas versus Daniel Valles. Announcement of council, please.
Roa King for the state of Texas.
Good afternoon, Your Honor. Eduardo N. Lerma and Veronica T. Lerma on behalf of Daniel Valles.
Mr. Lerma, is she here? I don't see, is there anyone in the waiting room, Mr. Manufo?
No, Judge.
No? Okay. All right, Mr. Lerma, Mr. Valles is appearing remotely from the jail annex. We were scheduled, actually, we weren't scheduled for anything. The court received a motion for continuance from defense counsel. Mr. Lerma, you may proceed.
Thank you, Your Honor. There's Mr. Valles now. Your Honor, we're still not finished with the we have. He has not finished. He's had an important amount of work to finish up, and he is expeditiously and diligently trying to finish up the work he's doing for us. And once that happens, Your Honor, we will continue to render effective assistance of counsel. I visit with Mr. Valles weekly. He's fine with a continuance, and the defense is fine with a continuance. I know this case has been going on for 3.5 years. We've been on the case approximately 5 months, and we've been moving on this case, believe me, Your Honor, as quickly and diligently, consistent with effective assistance of counsel as fast as possible.
Okay. Let me see. On June 7th, okay, and that's the only basis for the continuance, really. Okay, Ms. King?
Your Honor, the state respectfully opposes the motion for continuance. The defense attorney, Mr. Lerma and Ms. Lerma, asked for their client to be transported and seen by their doctor that they have hired on March 23rd, 2022. Statutorily, there is a 30 days to have a report completed and sent out by the mental health physician. I received this email asking if the state is in agreement with the motion for continuance on June 8th. Trial is specially set for June 23rd. Your Honor, that was more than 2 months at least, and less than 2 weeks away from trial that defense counsel brought this. I don't know when they followed up, but that this was brought up to the court's attention and asking the state if we would agree.
So let me stop you right there. The motion for continuance filed on June 6th reflects that the witness, Dr. Harry Wilson, that's who is referenced in the motion for continuance. Is that right, Mr. Lerma? That's who you're talking about?
That's correct, Your Honor. There's 2 different set of experts involved in this case.
Right. And so there was a different, the March, I think it was an in-person, I remember because we accommodated that meeting if it was back in March, and that was a different individual. It's not Dr. Wilson. So just so you know that, Ms. King. Go ahead.
Let me see. So okay. So, I mean, from reading the motion for continuances, I believe it says on June 7th that Dr. Wilson advised counsel that he was not finished with the review. Whether or not the doctor, that's when he informed Mr. Lerma, Ms. Lerma, it was also a duty on defense counsel to follow up with the doctor, knowing that this trial has been set now for a very long time and it's been reset multiple times. Just as the state has the duty to kind of follow up on inquiries, that I believe that's only fair to defense counsel. And also, Your Honor, the longer we keep on resetting this trial, I do have some witnesses that the state intending to call to the jury trial that are going to move. One of them is the deceased sister. She will be moving out of state in July. So therefore, the state opposes the motion for continuance, Your Honor.
Let me see. Mr. Lerma, do you have anything else?
Well, Your Honor, we haven't sat on the case. There's other parties that have sat on the case for approximately 3 years. And like I'll state again, we've only been on the case approximately 5 months, more or less.
And Your Honor, if I may, that was, I mean, whenever Mr. and Ms. Lerma were retained, that is something that they became aware of. Whether or not past counsel were on for 3 years or 1 year, we're beyond COVID. Now murder trials are being set. And I believe that was kind of known to defense counsel when they were retained.
So the defense counsel subbed in February 7th, or at least that's when that was filed. I don't know when I signed off on the order. Let me look at something. Yeah. You know, per the discovery order, the standing discovery and pretrial, court standing pretrial order, you know, this expert, Dr. Wilson, is really not timely. The order requires that, you know, 30 days before trial, there's disclosure of a testifying expert by the parties. I mean, how long have you had this expert in mind, Mr. Lerma?
Just until recently,
Yeah.
and the court was notified of it.
Okay, anything else?
No, Your Honor.
Okay. The defense request is denied. So we are still scheduled and set for trial on June 24th. Let me go back and look at, we have the final hearing plea deadline on June 21st. So that's next week. At that final hearing plea deadline, I will ask for the attorneys to have anything filed that will require hearing before our trial setting. Okay, because I will only have about a week. No, not even a week. No, you have to have things filed, you know, I mean, to me, we're going to trial. So if you're going to need a hearing on something, I'm going to need it before the 21st to see if we can schedule you before the actual trial setting. For that trial, yeah, we have that one, 4 panels in the courtroom. So we'll be starting on Thursday, the 23rd, with a panel in the morning, panel in the afternoon, and then Friday, panel in the morning, panel in the afternoon. Okay. Anything else?
That's all, Your Honor.
Ms. King, is there a rec?
Your Honor, it's 40 TDC.
Okay. All righty. Then if I don't hear from you, we'll see you on the 21st. Thank you very much.
Very well.
Mr. Marufo, for that final hearing plea deadline, we need to transport the defendant. I show it at 9:30 in the morning. And so just out of an abundance of caution, we're going to do that in person. Mr. Lerma, part of the reasoning there also is in case we need to have some type of substantive hearing, your client is present and will be able to do it in the courtroom. Okay.
My excuse, Your Honor.
Yes, thank you very much. Who's next, Mr. Marufo?
Back to page 4, Judge. Annex, may we have Fernando Ayala?
Good afternoon, Judge. How are you?
I'm well, thank you. Mr. Ayala,
Okay,
can you hear us okay?
I can.
Okay. Sir, did you?
Clause number 2022 0D0 50 and 2020-0D03281 and 2022-0D00152.
Hold on a
And
second. Where's
2021
that background noise coming from? All right, go ahead, Mr. Moon.
2021-0D00763, State of Texas versus Fernando Ayala. Announcement of council, please.
Roa King for the state of Texas.
Good afternoon, Your Honor. Regina Arditi on behalf of Fernando Ayala, and we are ready, Your Honor.
We are scheduled for status conferences and I believe revocation hearings on these various cases today, but I have received plea paperwork on cause number ending 0050, indicating that your client intends to plead on that case. Is that correct, Ms. Arditi?
That is correct, Your Honor.
Okay, Mr. Ayala, is that also correct? Your non-probation case, on one of them, there's a plea set for today. Are you in agreement with that?
Yes, that is correct.
Okay, so we're gonna get started in cause number 2022-0D00050. Mr. Ayala, I'm gonna be asking you some questions, so I need to swear you in. If you would, please raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
I do.
Thank you very much. You can put your hand down. If you would, please state your name and date of birth for the record.
Fernando Ayala, 10/3/1988.
Mr. Ayala, as I mentioned, I have documents, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Ayala, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
I do.
Did you understand everything contained within that document?
Yes, I did.
Ms. Arditi, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor, I have. Thank you.
And did you explain the plea papers to your client?
Yes, I did speak with my client and explained the plea papers and asked him if he understood or he had any questions.
You believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
Yes, I do. Thank you, Your Honor.
Mr. Ayala, are you satisfied with your attorney's representation of you?
I am.
Ms. Arditi, do you have any reason to believe that your client is not presently competent to enter his plea?
No, Your Honor, I do not. Thank you.
Mr. Ayala, have you ever been found incompetent by any court?
I have not.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Sir, are you a U.S. citizen?
I am.
Where were you born? I'm
My-
sorry, Ms. Arditi, there is some background noise. I don't know if it's a television but it needs to be quiet while we're in court.
I understand, Judge. There's nothing here. I don't have anything on, but maybe it's some kind of background that I'm not aware of. I apologize.
Sure, okay. I see you're muting, so if you'll just continue to do that. Mr. Ayala, you're a U.S. citizen?
I am.
Where were you born?
Miami, Florida.
Okay, in this case, you were charged with the offense of burglary of habitation, which is a second-degree felony punishable from anywhere between 2 and 20 years in prison. To that charge, sir, what is your plea? Guilty or not guilty?
Guilty.
Are you making your plea freely and voluntarily?
I am.
I will find you are making your plea freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element of the offense charge, burglary of habitation beyond a reasonable doubt. Your Honor, the defendant is pleading to 3 years probated for 3 years of straight probation, and the remaining terms and conditions on the state's plea paperwork. Further, the state will dismiss cause number 2022-0D00152. And at this time, the state moves to admit Exhibit 1 as the state's plea paperwork, Exhibit 2, Article 3914 disclosure, and Exhibit 3 as the indictment.
Any objection?
No objections, Your Honor.
Without objection, states Exhibits 1, 2, and 3 are admitted. Ms. Arditi, is that your understanding of the plea agreement?
Yes, it is, Your Honor.
And Mr. Ayala, is that your understanding of the plea agreement as well?
It is.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Ayala, do you recall reviewing the trial court certification with your attorney and signing that document?
I do, Your Honor.
It was signed by your attorney and signed by the court as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of burglary of habitation, and I will sentence you according to the plea agreement at 3 years confinement in the Texas Department of Criminal Justice Institutional Division that will be suspended for a period of 3 years of community supervision. There will be a $4,000 fine, $3,800 of that is probated, 200 hours of community service, court costs, curfew, urine and breath analysis, theft counseling, no contact with the complainants. You will be placed in the BHRTC treatment program, and your other probation cases ending 3281 and 0763 will also be modified to BHRTC. As soon as I receive the dismissal on cause number ending 0152, I will sign that, and then you should be good to go to BHRTC. Is there anything further, Ms. King or Ms. Arditi?
Nothing further from the state, Your Honor.
The only thing, Judge, if you can make sure that my client has minimal probation fees because he is unemployed and he will be at the BRTC right now. Thank you, Your Honor.
And you're appointed, Ms. Arditi?
That's correct.
Okay, so due to his indigency, we will reduce his probation fees to $25 a month. Carla, if he's not already at $25 on the probation, the other probation cases, we can go ahead and reduce them there as well and make it retroactive if it's not already at that point.
Thank
Carla,
you.
what else do you need from me on the BHRTC end? Anything? No? You said-
Nothing, Your Honor.
Okay, good luck to you, Mr. Ayala. Thank you, Ms. Arditi.
Thank you, ma'am. May I be excused, Judge?
You may.
Thank
Who's
you.
next, Mr. Marufo?
Bottom of page 5, Judge. Annex, may we have Alfredo Garza?
Give me 1 second, Mr. Let me see. Mr. Marufo, did we have a PSR on him? Oh, yes, there it is. Never mind. I just found it. All right. Did we get announcements already? Sorry.
Judge. In
Go ahead.
cause number 2022 0D01666, State of Texas versus Alfredo Garza. Announcement of council, please.
King for the state of Texas.
Good afternoon, Judge Perez, Luis Islas for Alfredo Garza.
And Mr. Garza is appearing from the jail annex. We are scheduled for a bond hearing today. Mr. Islas, you may proceed. Good afternoon.
Good afternoon, Your Honor. Mr. Garza is charged in a 2-count indictment with
Mhm,
failure to register.
mhm,
And he had been at the halfway house in Horizon City,
mhm.
February 7th. He was under the impression that he had been released from having to remain there. So he left and he went and lived with his family in Lubbock, Texas. The halfway house people and his parole officer had a different view. But I point that out, Your Honor, because when a warrant was issued on the case, it was, I think, March 1st of 2022, the authorities knew exactly where to find him. And that was in Lubbock, Texas. We're here asking the court to consider maybe a split bond with a PR portion and a cash corporate surety portion on the bond. And that's all I have.
What is his bond?
100,000.
And was that on some type of PR violation, or is that just what it was based on, the warrant or whatever?
It was when the warrant issued, that's what the bond was set at.
Understood. All right, Ms. King?
Your Honor, the state opposes any bond reduction based on, I believe, based on two factors. The first one, the defense counsel briefly touched upon, which was the parole. Allegedly, the offender did abscond as of February 7, 2022 from the El Paso halfway house. The second factor is the criminal history. There is an extensive history, and it starts in 1990 with the DUI. July 1990, resisting and evading, and the third count of assault. I don't have a disposition. August 1990, carrying prohibited weapons and a burglary of a
So
habitation.
let me just, I'm sorry, Ms. King, I don't mean to interrupt, but sometimes with this PSR system, I think I have a pretty good view of the previous history. But I also show, I want to kind of just jump up to September of 2021. I show an offense in Lubbock, which I don't know, fraudulent use of identifier. Are you seeing that as well?
Yes, I do. The fraud use possession more than, no, less than 5 items, state jail.
Okay.
So, ma'am,
Hold on. Mr.
I don't see
Garza.
how that could be. He was at the halfway house at the time.
it got dismissed.
Got dismissed. Anything else from either Ms. King or Mr. Islas?
Excuse me, Your Honor?
Anything else?
No, Your Honor.
Okay, the request to reduce bond is denied. Thank you, Mr. Islas.
Mr. Garza, would you sign the waiver of arraignment and send it back to me, please?
Yes. Who do I send this motion to, sir?
So
Mr. Islas?
I'm gonna go ahead and ask you to speak with your attorney at another time, just so you know, Mr. Garza, everybody's on here, including the state prosecutor. So,
I got the motion to reduce bond where it shows that we're supposed to be able to afford a bond, ma'am. I mean, like my lawyer said, I went and registered. I didn't run from these people. I didn't, they knew where to find me because I was registered in Lubbock.
I
Mr.
understand.
Garza, I advise you
Your-
not to say anything more.
Your attorney argued that, so you'll need to speak with your attorney, Mr. Garza. The bond reduction is denied. Thank you, Mr. Islas.
This been
May I be excused?
United either, the motion.
You may, Mr. Islas. Thank you very
Thank you.
much. Mhm. All right, who's next?
Bottom of page 9, Judge.
Mhm.
Next, may we have Jason Zamora?
Is that Mr. Zamora? Okay. Mr. Parra?
Annex
Good afternoon, Your Honor. Yes, it is.
Okay.
With longer hair than I remember, yes.
in cause number 2019 0D02513 and 2020 0D03371, State of Texas versus Jason Franklin Zamora. Announcement of council, please.
Roa King for the state of Texas.
Victor Parra, Your Honor. Good afternoon on behalf of Mr. Zamora.
Good afternoon, and Mr. Zamora is appearing from the jail annex. I believe we're only scheduled, are we just scheduled for status conferences today?
That's correct, Judge. I think the state had been working with me on getting some reasonable recs, and there's currently a couple of P files. I'm waiting to get indicted. I believe we already did a motion, and I'll talk to the state thereafter to see where we're at.
Okay, so we're gonna need to get Mr. For my purposes, Mr. Parra, I'm gonna need to get him on a trial track, just so we don't lose track. What are the P files? Ms. King, can you give me an update?
Your Honor, the one I see is a misdemeanor, POM less than 2 ounces, date of offense, May 18, 2022. I believe there is another one, let's see, possession, PG1 between 1 gram, less than 4 grams. That's the only ones I see.
That's correct, Your
And
Honor. Those are the
they
two.
arise out of the same incident?
No, Your Honor.
No? Oh, okay.
Let me
What's the
They're
alleged
not.
date of offense on those cases?
The possession of marijuana less than 2 ounces is May 18, 2022. And the one with PG1 between 1 gram and 4 gram is December 2020.
December 2020?
That's what I see.
Did you look at my notes? But I think that's one that was gonna be part of of the negotiation. He was out and I spoke to him and we had a plan. And I believe that, if I'm not mistaken, that was gonna eventually be declined if we took the deal. So then the only pending one is the POM then.
Okay. Well, I need to get him on a trial track. Myrna, can you give me a date? I'll say October. He's in custody, so. If you all are gonna work it out, even if it's with P-file cases or whatever, you all should be able to do that.
Yeah.
He's been in a little over, probably close to 30 days.
October 7th, Judge?
That's good, October 7th. Mr. Parra,
Miss-
nothing outstanding there with that date that,
No. And Ms. King, if the recommendation stands and that PFAS is gonna be declined, you can send me the paperwork.
Okay, I will.
Thank you.
so we'll have our next setting be in about 30 days, Myrna, if we'll go ahead and schedule them like that. And if we get plea papers before then, Mr. Parra, we'll set you up with a plea setting, okay?
Absolutely. Thank you so much.
All right, thank you, Mr. Zamora. Thank you, Mr. Parra, you're excused.
Thank you, Judge.
All right, who's next?
Back on page 7, Judge.
Mhm.
Annex, may we have Isaac Martinez?
Ms. Caballero, are you there?
Your Honor, she's logging in.
Okay, perfect.
Thank you.
Thank you. I'll go ahead and call it Mr. Murphy.
Good afternoon, Your Honor.
Good afternoon, Ms. Caballero. Ready to go with Isaac Martinez?
Yes, Your Honor.
Okay, perfect. Calling cause numbers 2020-0D0, 5259 and 2020-0D0, 3792. State of Texas versus Isaac Martinez. May I have announcements, please?
Roa King for the state of Texas.
Teresa Caballero on behalf of Mr. Martinez.
Actually, I did have one question for council. The plea papers reflected $1,500 of restitution. I believe that related to a case to which he is not pleading. Was the agreement to just carry the restitution with the 2 cases that he's pleading on?
Your Honor, good question. I'm going to flip over to see my notes. 1 second.
Sure.
Okay.
Your Honor,
Go ahead, Ms. King.
I don't believe we have had that discussion, but that would be fine with the state to just carry it over as part of the probation.
Were you aware of the restitution, Ms. Caballero?
Were those papers signed today, Your Honor?
Yesterday? Well, by you yesterday, I don't remember the date that your client signed them. Oh, I didn't get them via email. They were hard copies.
Okay. He signed last week. You know, I don't recall the restitution at all, to tell you the truth. And what does it say?
So the plea papers indicate that there's $1,500 of restitution. Ms. King, correct me if I'm wrong. I think they arise out of cause number ending 4282, which I understood to be a dismissal because the plea papers say $1,500 for dismissal. Now, obviously, I'm not going to carry one last case waiting to see if we get $1,500 of restitution. So if that was the agreement, I was just going to include it on the cases for which he's pleading. And it looks like plea papers were signed on the 9th.
Yes, they were signed last week. I talked to him through a jail call and went over the papers with him, but I don't think I went over that. And Ms. King, do you mind if we scratch that from the paperwork and deal with that when that case comes up?
What do you mean when the case? Because that's part of, you want to leave that one case pending?
Oh, okay, yes. No. Let's go ahead and go. Let's sign.
Okay, so what I'll say this for your client's benefit, so that he hears, Ms. Caballero, if there is an issue with the restitution, we can obviously, I think, readdress that on his probation. I'm not sure what has been discussed there.
Okay. We want to take it. We want to take it.
Okay. So Mr. Martinez, so you know, when we get through this plea, there's going to be an issue of restitution. I will also let probation know that, you know, if we run into any issues, to bring it to the court's attention as part of the probation. All righty. Okay. So everybody ready to go then?
Yes.
Okay. So we are scheduled for pleas in each of these cases. I only called the 2 cases for which Mr. Martinez has indicated that he is actually going to plea, as there are going to be dismissals forthcoming in the remaining cases. So, Mr. Martinez, I'm going to be asking you a series of questions regarding your pleas today in cause numbers ending 5259 and 3792. So I need to swear you in. If you would please raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth? Mr. Martinez, I cannot hear you.
Yes, ma'am.
Okay, please speak loudly enough, okay? Because sometimes the audio is a little tricky. You can put your hand down. Also state your name and date of birth for the record.
Isaac Martinez, 7/29/99.
Mr. Martinez, we are scheduled, as I mentioned, for pleas today in these 2 cases. I'm going to ask you about documents, the first of which is marked as State's Exhibit number 1. Those are the plea papers for each of these cases. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Martinez, do you recall reviewing State's Exhibit number 1 for each of these cases with your attorney and signing those documents?
Yes, ma'am.
Did you understand everything contained within the documents?
Yes, ma'am.
Ms. Caballero, have you had more than 10 days to prepare defenses in these cases?
I have.
And did you explain the plea papers to your client?
I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his pleas today?
I do.
Mr. Martinez, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Ms. Caballero, do you have any reason to believe your client is not presently competent to enter his pleas?
I don't.
Mr. Martinez, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
So based on your testimony, your attorney's representations and my observations of you, I'm going to find that you are competent to enter your pleas today. Sir, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Here in El Paso.
El Paso, Texas?
Yes, ma'am.
Okay. So in cause number 2020-0D05259, in count 1, you were charged, in counts 1 and 2, you are charged with the offense of aggravated robbery. Count 1, what is your plea? Guilty or not guilty?
Guilty.
Count 2, guilty or not guilty?
Guilty.
And in count 3, you're charged with the offense of unlawful possession of a firearm by a felon. To that charge in count 3, what is your plea? Guilty or not guilty?
Guilty.
In cause number 2020-0D03792, count one, again, you're charged with aggravated robbery. To that charge, what is your plea?
Guilty.
And in count two, unlawful possession of a firearm by a felon, what is your plea?
Guilty.
As to both of these cases, are you making all of your pleas freely and voluntarily?
Yes, ma'am.
I will find you are making your pleas freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element and count of the offense charged, count one and count two of aggravated robbery in cause number 2020-0D05259. Sorry, 259, and count three of unlawful possession of firearm by a felon. And further, burglary of a habitation in cause number 2020-0D03792 beyond a reasonable doubt. Your Honor, the defendant will plead to a 10 years of deferred probation in the aggravated robbery and 10 years suspended to 10 years in straight probation in count three to run concurrent with cause number 2020-0D03792 and restitution amount of $1,500 and other terms and conditions stated on the state's plea paperwork. Further, the state will dismiss 2019-0D03258 and 2019-0D03256 and 2019-0D03254, 2019-0D03752, and 2019-0D03251, and 2019-0C0371, and 2020-0D04282. And at this time, the state moves to admit Exhibit 1 is the state's plea paperwork, Exhibit 2, Article 3914 disclosure, and Exhibit 3 is the indictment.
No objection.
Without objection, states Exhibits 1, 2, and 3 are admitted in each case. Ms. Caballero, is that your understanding of the plea agreement?
It is, Your Honor.
Mr. Martinez, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled the Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because these are plea bargained or negotiated cases, you do not have an automatic right of appeal. Mr. Martinez, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
It was signed by your attorney and signed by the court as well. Finally, as to count 3 in cause number ending, counts 1 and 2 in cause number ending 5259. And count 1 in cause number ending 3792. Mr. Martinez, do you recall reviewing a motion for deferred adjudication in each of these cases with your attorney and signing that document?
Yes, ma'am.
Ms. Caballero, have you explained to your client both the benefits and detriments of deferred adjudication?
I did, Your Honor. And in fact, I really didn't like this plea offer. And I had encouraged my client to consider a time offer because of the dangers of deferred. But he did give a great thought, and he did talk it over with his family. And he did call me back to give me the answer. So yes, that was discussed at great length.
Mr. Martinez, you heard what Ms. Caballero just said. You had the full opportunity to consider all of the different factors involved with being on this type of community supervision, deferred adjudication, and that is your desire to do that today?
Yes, ma'am.
You understand that if you violate any condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment for these offenses. Do you understand that?
Yes, ma'am.
And are you still asking the court to grant you deferred adjudication?
Yes, ma'am.
As to counts 1 and 2 in cause number ending 5259, and as to count 1 in cause number ending 3792, I will find there is sufficient evidence to substantiate findings of guilt. However, I will not enter findings of guilt at this time. Instead, I will defer further proceedings and place you on deferred adjudication pursuant to the plea agreement for a period of 10 years. I will withhold on the conditions because obviously on the other counts, we are doing straight probation. As to count 3, the unlawful possession of a firearm, on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. And actually that will be also for count 2 in cause number 3792, find you guilty in both of those of unlawful possession of a firearm by a felon. In those cases, you will be, I will punish you according to the plea agreement to 10 years confinement in the Texas Department of Criminal Justice Institutional Division that will be suspended for a period of 10 years of community supervision. The terms and condition of all your probation cases is that you will have a $4,000 fine. Ms. Caballero, I can't remember. I got to imagine, were you court appointed or were you retained? He's been in custody for so long, he's indigent, so I don't know.
I don't have my file in front of me, Your Honor. I don't know. I never pay attention to that, to tell you the truth. My office is very good about, so my secretary just wrote me, I'm retained.
Okay, so although you're retained, he's been in custody for plus 700 days. And
Okay.
so based on his indigency, I am going to suspend, probate the entirety of the fine. What that means, Mr. Martinez, is you will not have that financial obligation on the fine unless you are non-compliant with your probation. So as long as you're compliant, you're not going to owe the fine. There are some other financial obligations, but that isn't going to be one of them. If at some point you are not compliant, they can come back to collect the entirety of the fine. 200 hours of community service, court costs, urine and breath analysis, curfew, theft, theft counseling, no contact with the complaining witnesses. Ms. Caballero, I'm sorry that I didn't think of this before we started the plea. I am also going to order that he not possess any weapons. Obviously, he's prohibited from doing that anyway. I mean, if anything were to come up, Mr. Martinez, that is going to be a condition of your probation.
Yes,
Your Honor, when you say weapons, are you talking about firearms?
Firearms, yes. No firearms or ammunition. I mean, he shouldn't be. Anyway, he's pleading to 2 of them today. The restitution amount that will be, that is owing out of cause number 4282 will be ordered pursuant to the plea agreement here. So it's $1,500 of restitution. All of these cases will run concurrent with one another. Okay, sorry, I didn't know if we lost Ms. Caballero. All of these cases will run concurrent with one another. As I mentioned before we started the plea, Mr. Martinez, you're to get with probation. If at some point there becomes an issue on the restitution, you may request a hearing in front of the court if there is some issue with the amount of restitution. He is also, his probation fees will be reduced to $25 a month based on his indigency. What else am I missing here, Ms. Caballero?
Nothing, Your Honor.
I will also sign dismissals in the remaining cause numbers ending 4282, 3258, 3256, 3254, 3752, and 3251.
Thank you.
Anything further from the state of the defense?
Nothing
No,
further.
Your Honor.
Good luck to you, Mr. Martinez.
Bye-bye, Mr.
Thank you, Ms.
Martinez.
Caballero. Take care. Oh, do you have one more? You have one more, no?
Yes,
I
Judge.
do, Your Honor. I need to address that.
Okay,
On page 9, Judge.
okay.
Annex, may we have Jesus Luna Vasquez?
sir.
And Ms. Noyola is here for who?
For Reyes. For Mr. Reyes on page 8, Judge.
Okay, we'll do that one next. Is that Mr. Vasquez?
Yes.
Yes. Okay, all right, go ahead, Mr. Manu.
In cause number 2021, 0D02820, State of Texas versus Jesus Luna Vasquez. Announcement of council, please.
Roa King for the state of Texas.
Teresa Caballero on behalf of Mr. Vasquez. Your Honor, I'm not ready to proceed on this. So the plea papers I got today and they were given to my client and he signed them, but that wasn't under my supervision and I haven't talked to him. or gone over them.
Okay, let me ask without, asking too much detail. Obviously, don't tell me anything. But he is someone that I mean, is it a situation where we're close and there's just some minor details? Or are
No,
we
we're
really?
agreed. We're agreed.
Oh, okay.
But when
Okay.
you get to the part of the colloquy where you ask me if I've gone over the plea papers with my client, the answer is going to be no. And I'm assuming we've discussed what we want to agree to, but I did not go over these papers with him. Now, if you want to give me a brief, while you go to the next hearing and you can put me in a breakout, that's never worked out for me when somebody's in jail. I'm happy to do that.
I just assume I can do a couple of things. So I can have you all come back on Thursday. We could even do it in person if you think it's actually going to be a plea. If not, I can put you out 1 week and we can come back just as we are right now. And if it's all taken care of, and we have a plea, I just want to make sure, I don't want to lose my jury panels that I have this week because he's been in custody for a while.
I can bring him on Thursday. No problem.
Let's do that. Can you do, if you can do Thursday morning, I'm flexible. I'll set it for 9 and have him transported at 9. And if you can get here, just let us know when you can get here. Okay.
I'll be there.
All righty.
I'll be there.
So
Thank you, ladies.
Mr. Vasquez, we're going to have you transported over on Thursday so you can meet with your attorney. Okay.
Your Honor, Mr. Vasquez is a Spanish speaker.
Ándale.
There you go.
Señor Vázquez, su abogada pidió a la corte que hablar con usted aquí en la corte en persona. Bueno, la corte quiso hacerlo en persona, solo vamos a transportar del oh my gosh, cárcel.
Vamos a tener la audiencia el jueves a las 9 de la mañana para que yo tenga la oportunidad de hablar con usted, señor, directamente, personalmente.
Thank you, Teresa.
You're welcome. We need to help each other out here.
My Spanish goes away pretty quickly. I think I have it and then I don't. ¿Está bien, Mr. Vázquez?
Muy bien, estoy bien.
Nos vemos el jueves. Thank you, Ms. Caballero.
Okay, thank you, ladies. Bye-bye.
Bye-bye. Okay, who's next?
AJ Judge. And next, may we have Ricardo Reyes.
Poor Ms. Noyola's going, aye, Judge. What happened? I forgot you were sitting there, Ms. Noyola. Okay, all right. Ready? Or is this the one we need the interpreter? Yes? Okay, so
Yes.
Ms. Noyola, go ahead. Oh, well, we don't need to set them up, right? We just need the annex to, and I'll pick English and mute original audio. Okay. Hi, Missy Bobbin. All right.
Your Honor.
When everybody's ready, let me know. Beautiful. Go ahead, Mr. Motherful.
In cause number 2021 0D0 2427 and 2017 0D0 1391, State of Texas versus Ricardo Esteban Reyes. Announcement of council, please.
King for the state of Texas.
Deborah Bobbin covering for Ms. Pages. For Mr. Reyes, ready, Your Honor.
And Mr. Reyes is appearing from the jail annex utilizing the assistance of a court interpreter. We are scheduled for both a probation status hearing in the 1391 case and a status conference in 2427. Let me go ahead and get an update from the attorneys. Ms. King, I show a jury trial we have in August. So what are we doing?
Your Honor, I believe we were waiting on a P file and I see that it was finally accepted and screened by our office.
Is that the theft?
Yes, that's the theft of, it's a misdemeanor, theft of property less than $750.
Do we have any other cases that we're anticipating or is that everything?
I believe that's everything.
Judge, if I may. The last time we were here, there was an indication there was a debit card, credit card abuse case that was still pending contact with the complaining witness by the detective.
Oh,
Did we get an update on that one?
I remember. Give me 1 second. Your Honor, we still don't have the case, so I'm And I have not received anything from the detective. She was having a hard time getting in contact with the complaining witness. And that's why she was pending presentation to our office.
Okay. So that might, I don't know if it's going to be something ultimately to consider or not, but I'm not going to change anything. We have our final judges July 19th and then an August trial setting. So I'm just going to keep the dates. I see there's some objection on the, I guess, the 24, 27 on count 2. So if anybody needs a hearing on anything outside of those dates, please request them via email with your pleading, okay?
Will do, Your Honor. Thank you.
Thank you very much. Anything else? If not, we're good to go.
Nothing from the defense.
Thank you very much. Thank you, Mr. Reyes. Your attorneys will be in touch with you. Okay, who's next? And I guess, does anybody else need an interpreter?
I do, Your Honor.
Who's your client?
My client is Gerardo Martinez.
Gerardo Martinez.
I believe he does understand English, Your Honor, but I speak with him primarily in Spanish.
Okay.
You have an interpreter.
Sure, yeah, we'll take care of it. Is Gerardo Martinez, is he at the annex or the
He's at the annex, Judge.
Okay.
Annex, we have Gerardo Martinez.
Mr. Vargas, offhand, do you know the bond amounts?
I do. It's 20,000 on the indecency and 100,000 on the sexual assault.
Okay. All right. Okay, so if we can get the interpreter function going again, please.
Hey, yes, ma'am.
Okay, go ahead, Mr. Marufo.
In cause number 2022-0D01005 and 2022-0D01495, State of Texas versus Gerardo Martinez. Announcement of counsel, please.
Joaquin for the state of Texas.
Rene Vargas on behalf of Mr. Martinez.
Okay, and we are scheduled for bond hearings in each of these cases. Mr. Martinez is appearing from the jail annex and utilizing the assistance of a court interpreter. Mr. Vargas, you may proceed.
Thank you, Your Honor. So I am co-counsel on this case along with Ms. Pages, and I've been familiar with Mr. Martinez ever since the initial sexual assault landed in JMAG and P-file status. And just to give the court some background on that, which I believe will inform the court's decision about these bond hearings, is that first he was arrested for the sexual assault. The complainant in that case is the daughter of his then live-in girlfriend. That allegedly happened January 10th, 2022. He was arrested January 11th, 2022, and released on a $50,000 bond with a $5,000 surety component. He was released, was doing well, reporting to PR according to the combined PR conditions on that bond, Your Honor. And then in March, the complainant in that case, in the sexual assault, and her mother reported that he was contacting her, etc. He was rearrested. We had another bond hearing in the JMAG where both mother and complainant actually showed up in person to the Zoom hearing. Suffice it to say that under cross-examination, Judge Ruben Nunez found them unreliable and reinstated his bond and released him again. Again, this is all on the record. There were some pretty bad text messages sent from the complainant's mother to my client, etc. Not to belabor the point, going to this indecency case, Your Honor, this indecency case was alleged to have happened to another relative of the complainant's mother, my client's ex-girlfriend, which is the complainant's grandmother. So the complainant, there's one woman, his ex-girlfriend, her daughter has a case against my client. Her son's daughter has a case against my client now. Keep in mind, that the sexual assault occurred supposedly January 10th. Now, in the child's statement, she says that this occurred, a touching over the clothes occurred January 25th. I think those dates are important because this is supposedly 2 weeks after a sexual assault, where he's still invited by that same family to a birthday party, etc. Not to go too far into the defense, but there was an altercation at that party. Mr. Martinez is not very well liked by his ex-girlfriend's family. And again, so there we have some unreliable, complainants. Again, Judge Nunez found them unreliable and reinstated his bond. So right now he's in on $100,000 bond for the sexual assault that was initially a $50,000 bond with a $5,000 cash surety component. This indecency case has a $20,000 total. I have spoken to Mr. Martinez regularly. He does have quite an extensive rap sheet, Your Honor, but he does come back to court. He does take his medicine. I don't think anything in his rap sheet is anywhere close to this severe. I believe he has a family violence or two and a violation of protective order. But no sex crimes, no crimes against children, etc. So we'd ask that his bond be lowered to about that same range, Your Honor. He is still living with his current girlfriend, who I'm in communication with. I've spoken to her today, in fact. She's in contact with the bond company, and depending on what happens today, they would consider reinstating the initial cash surety bond that he was out on the sexual assault. Again, because he has been a model client for theirs, has been reporting to PR bond. He wasn't revoked for any technical violations, only these alleged subsequent offenses. He's a landscaper. He lives at the same apartment on Loma Land. I can provide that for the court if needed, but he does live with another girlfriend. And he wants his day in court, obviously, to fight these allegations, which he claims are spurious. So we'd ask, the boss could say the same. We just ask for a lowered surety component in the area of maybe, $5,000 total, so he can post bond again, go to work, stay away from the family, which he has been doing, Your Honor, and, wait for his day in court.
Is that all, Mr. Vargas?
It is, Judge.
Okay, Ms. King, go ahead.
Your Honor, the state respectfully opposes the bond reduction. Other than the criminal history that even though there has not been any sexual or assault of any nature sexual assault cases or of children cases, there has been a conviction of assault family violence. And also the complaining witness in that case, I believe 2015, she has also been in touch with our complaining witness. We have had actually continuous contact with the victim in one of the sexual assault of a child case. And she has expressed to us the multiple times that she was aware of the defendant actually violating his bond order. And Your Honor, just from the nature of the offenses, the state is respectfully opposes the bond reduction. I personally have not spoken to the complaining witness in both cases. I do have a meeting hopefully tomorrow afternoon.
I'm just looking up on I'm trying to see. I saw Judge Nunez's bond order, I believe, the one that was 50, that was split 545. I'm just looking up.
I think that was the new order issued after the hearing we had pursuant to his bond being revoked, Your Honor.
Mm-hmm.
I will add in that March hearing in the JMAG that nothing was mentioned about this potential indecency with the child case from the complainant's grandmother or the complainant's aunt, as it were. even though that was alleged to have happened in January.
So on the indecency case, the bond order, I'm just wanting to make sure, because you told me it's 20,000, so it's 19.5 cash surety, 500 PR, right?
I believe so, Judge. And that's the portion we'd obviously be asking to lower cash surety portion.
Yeah. You know, on the indecency case, the bond request, the bond reduction is denied. I think the bond is appropriate. So I know Mr. Vargas is probably not going to get you, you know, with that additional case, it's probably not going to get you where he needs to be in terms of what he can afford. Honestly, on the sexual assault case, it's just 100,000 straight cash surety.
I believe so, Judge, since he was arrested and they turned in their certificate of incarceration. I just asked that maybe those be returned to the original terms, 50,000 total with a $5,000 cash surety component. And I believe with that, Mr. Martinez and his girlfriend can work with the bond company on reinstating that initial bond and then posting a new bond on this case.
And that request will be granted. And so I'm looking at the JMAG bond order on the sexual assault case. Marissa, if it's helpful, it's going to be reinstated at 5,000 cash surety, 45,000 PR, with all of the conditions that are on that March 30th bond order, to include obviously no contact, no direct or indirect contact with the complainants or anyone in their family. He is going to, the reporting terms to mirror the intensive supervision. So that's 1 a week, report once a week by phone, as long as the COVID protocol. If not, it will be once a week in person, subject to testing, commit no new offenses, may not use any illegal drug or alcohol, may not change his place of residence or leave El Paso County without the court's approval, and you must maintain all current contact information with the CJC office. You're not permitted to go within 200 yards of the address on Omar in Anthony, Texas, and then to comply with all other conditions. You are not allowed to possess any firearms, weapons, or ammunition. So Marissa, if you have any questions on the bond order, I'll refer you to the March 30th bond order, but then let me know if you have any other questions.
Yes, Your Honor, I've got that.
Perfect. Anything else?
No, Your Honor, other than some housekeeping measures, Mr. Martinez set for a arraignment on the 16th. But I've already signed that waiver arraignment and for Mr. Martinez and sent that to Ms. Hernandez, I believe. So if it's all right, we can cancel that hearing.
As long, do we have the paperwork? Let me see, signed waiver. We're 2 days away, sure.
Okay.
Is there, I know it's early on, but Ms. King, do you have a rec?
Not yet, Your Honor.
Okay. All right. So our next hearing isn't until our judges conference in August. If you all have anything outside of the scheduled hearings, then please let the court know via email with your attached pleading and we will get you scheduled.
Thank you, Your Honor.
Thank you very much.
May I be excused?
Yes, sir. And now I'm going to ask anybody else. I don't even see attorney. Who's left of attorneys? Brent Stevens. Okay. And Missy Bobbin's still here. I see you, Missy Bobbin. Does anybody else need the interpreter though, so I can let Miss Noyola be on her way? Okay. Miss Noyola, thank you very much.
Thank you, Your Honor. Bye.
Bye. Who's next?
Top of page 9, Judge, from the downtown facility. Downtown, may we have Eric Rodarte?
Yes, sir.
Who's got Rodarte?
Mr. George Driscoll.
Yes, Your Honor, I'm here.
Okay, go ahead.
In cause number 2022-0D00675, State of Texas versus Eric Rodarte, announcement and counsel.
Roa King for the state of Texas.
George Driscoll for Mr. Rodarte, Your Honor.
And Mr. Rodarte is appearing remotely from the downtown jail. We are scheduled for, is it a status conference today? Yes, status conference. Anything you all need to put on the record? What's going on?
Judge, I had filed prior to our last setting a motion to withdraw due to conflict due to a representation with a co-defendant. We had received some privileged communication with the co-defendant that leaves our office in a position where we would have an actual conflict to represent Mr. Rodarte as well. So I had filed that motion and you had asked that I get his response in writing as to whether or not he would approve our withdrawal, which I did, and then amended the motion to withdraw.
Okay, let me look at it. I don't know, Myrna, had I already looked at who to appoint, or if not, can you give me the next 5 attorneys, please? Mr. Rodarte, you understand your the public defender's position in this case? You understood the motion to withdraw?
Yes, ma'am.
Okay, perfect. So Myrna, I'm sorry, I was trying to check my emails to see if I'd asked, but I can't.
You didn't just, I'm looking at it.
Okay. So in terms of the public defender's office withdrawal, that is granted. We'll just, I want to see if we can let Mr. Rodarte know. The court will be appointing someone else to represent you. We are not scheduled again until August 18th for a judges conference, and then we have pretty much monthly settings after that. Your jury trial is scheduled in February of next year, Mr. Rodarte. In any event, the court will appoint an attorney. Thank you, Mr. Driscoll, for filing and following up with that. If there was a proposed order attached, we'll go ahead and sign off on it, okay?
Thank you, Your Honor. And be
All right.
excused.
Yes, sir.
Thank you.
Is there
Have a good day.
anyone else at downtown? Mr. Rodarte, we're going to get you a new attorney, okay? So they will be in contact with you as soon as we get that order out.
Yes, ma'am.
No,
Thank
ma'am, he's the only one.
All right, downtown, thank you very much.
Thank you.
Who's next?
Back on page 5, Judge.
Mm.
Annex, may we have Terrell Bonner?
Who's got, oh, Mr. Bobbin, you got Miss Bonner?
Yes, Your Honor, I'm covering the plate.
Miss Bonner, can you hear me okay?
Yes, ma'am.
Beautiful, I can hear you just fine, okay? All right, let's go ahead and call it.
In cause number 2019 0D00810 and 2019 0D01089, State of Texas versus Tyrell Bonner. Announcement of council, please.
Roa King for the state of Texas.
Deborah Bobbin, covering for Ms. Pages. Ready, Your Honor.
And we are scheduled today for plea hearings, Ms. Bonner. In each of these cases, Ms. Bonner is appearing from the jail annex. As I said, we're scheduled for pleas. So Ms. Bonner, I'm going to be asking you questions regarding your pleas today. I'm going to need to swear you in, okay? If you would raise your right hand, thank you. Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am. I mean, I do. I'm sorry.
Thank you. You can put your hand down. Ma'am, would you state your name and date of birth for the record?
Tara Monique Bonner, 1382.
Okay. As I mentioned, I'm going to ask you questions about documents you may have reviewed with your attorney, the first of which is marked as State's Exhibit number 1, one for each case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Ms. Bonner, do you recall reviewing both of State's Exhibits number 1 with your attorney and signing those documents?
Yes, ma'am.
Did you understand everything contained within the documents?
Yes, ma'am.
Missy Bobbin, I do need to ask because my notes, I show on the plea papers, one is for 45 days and one is for 46 days. Was that just a typo?
I think it was, Your Honor, but either way, she has more than enough days.
Okay, beautiful. Okay.
And
So,
I'm sorry, Judge, I did review the plea papers with Ms. Bonner personally at the annex.
okay, and have you had more than 10 days to prepare defenses in these cases?
Yes, Your Honor.
And do you believe, after explaining the plea papers, that she understood the admonishments, rights, and consequences of giving up these rights by entering her pleas today?
Yes, Your Honor.
Ms. Bonner, are you satisfied with your attorney's representation of you?
Yes, ma'am.
And Ms. Ibaben, you have any reason to believe your client is not presently competent to enter her pleas?
No, Your Honor.
Ms. Bonner, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who's found you mentally ill?
No, ma'am.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas today. Ma'am, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
I was born in Oakdale, Louisiana.
Okay. In cause number, well, actually, in each of these cases, you're charged with theft of property in an amount less than $2,500 with 2 or more previous convictions. In cause number ending 0810, what is your plea? Guilty or not guilty?
Guilty.
And in cause number ending 1089, what is your plea? Guilty or not guilty?
Guilty, ma'am.
Are you making each of these pleas freely and voluntarily?
Yes, ma'am.
I will find you are making your pleas freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element the office has charged in cause number 2019-0D0, 0810 and 2019-0D01089 of theft of property in an amount of less than 2,500 with 2 or more previous convictions beyond a reasonable doubt. Your Honor, the defendant is pleading to a 1244A, time served of 45 days, and other terms and conditions stated on the state's plea paperwork. And at this time, the state moves to admit Exhibit 1 is the state's plea paperwork, Exhibit 2, Article 3914 disclosure, and Exhibit 3 is the indictment.
No objection, Your Honor.
Without objection, states 1, 2, and 3 are admitted in each of these cases. Ms. Ibaben, is that your understanding of the plea agreement?
It is, Your Honor.
And Ms. Bonner, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the 1-page document entitled "The Trial Court's Certification of Your Right to Appeal." It is a document that explains your appeal rights. Because these are plea bargained or negotiated cases, you do not have an automatic right of appeal. Ms. Bonner, do you recall reviewing the trial court certification with your attorney and signing those documents?
Yes, ma'am, I do.
They were signed by your attorney and signed by the court as well. So on your pleas of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. In each of these cases, I will find you guilty of the offense of theft of property in an amount less than $2,500 with 2 or more previous convictions. And I will sentence you according to the plea agreement and in accordance with 1244A of the Texas Penal Code to 45 days confinement in the El Paso County Detention Facility. You will receive credit for any and all time that you have served, and the cases will run concurrent with one another. Is there anything further, Ms. King or Ms. Ibaben?
Nothing further from the state, Your Honor.
Judge, just for clarification, would the court cost also be credited with her jail time?
Sure, absolutely. Any excess jail time she has will go toward costs.
Thank you.
Anything else?
Nothing further, Your Honor.
Okay, thank you very much. Good luck to you, ma'am.
Thank you, Your Honor.
Take care. Who's next? Who has Mr. Horton?
I'm covering
Ms.
Judge.
Ibaben.
Okay, so let's do Mr. Horton's cases.
Annex, may we have Vincent Horton?
Oh, my goodness. Oh, okay. I did not make notes on Mr. Horton, probably because I feel like I've had these papers for a minute. Actually, Okay. All right, my apologies. Sorry, I didn't have it. Okay. All right. Did we already get announcements? I'm sorry.
No, Judge, in cause
ahead.
number 2019-0D0-5421 and 2020-0D0-0540 and 2020-0D0-1164, State of Texas versus Vincent Horton. Announcement of council, please.
King for the state of Texas.
Deborah Bobbin, covering for Myrna Page, is ready.
And Ms. Bobbin, do you recognize your client for appearing from the jail annex?
Yes, Your Honor.
Yes, okay. Mr. Horton, we are scheduled for pleas in each of these cases. I think one of them ending 0540 is getting dismissed. But in order to go forward with your plea, I'm going to be asking you questions. So I need to swear you in. If you would raise your right hand, please. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Okay. If you could, you can put your hand down. If you would, just raise your voice volume just a little bit. It's a little bit hard to hear you. Sir, would you state?
Is that better?
Way better. But would you state your name and date of birth for the record?
Vincent Jovan Horton, October 1st, 1988.
Mr. Horton, as I mentioned, we're scheduled for pleas in cause number 5421 and 1164. With each of these cases, you should have reviewed documents with your attorney, first of which is marked as State's Exhibit number 1 in each case. Those are the plea papers. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Horton, do you recall reviewing those documents with your attorney and signing those documents?
Yes, Your Honor.
Did you understand everything contained within the documents?
Yes, Your Honor.
Ms. Bobbin, have you had more than 10 days to prepare defenses in these cases?
We have, Your Honor.
And did you explain the plea papers to your client?
Your Honor, I did not. Ms. Page has reviewed those with him before she left on vacation.
And is it your understanding that Mr. Horton did understand the admonishments, rights, and consequences of giving up these rights by entering his plea?
Yes, Your Honor.
Mr. Horton, are you satisfied with your attorney's representation of you?
Yes, Your Honor.
And Ms. Bobbin, any indication that Mr. Horton is not competent to enter his pleas today?
No, Your Honor.
Mr. Horton, have you ever been found incompetent by any court?
No, Your Honor.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, Your Honor.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas today. Sir, are you a U.S. citizen?
Yes, Your Honor.
Where were you born?
El Paso, Texas.
Okay. In cause number ending 5421, well, actually, in each of these cases, you are charged with the offense of theft of property in an amount less than $2,500 with 2 or more previous convictions. In cause number ending 5421, what is your plea? Guilty or not guilty?
Guilty.
And in cause number ending 1164, what is your plea? Guilty or not guilty?
Guilty.
Are you making each of your pleas freely and voluntarily?
Yes, Your Honor.
I will find you are making your pleas freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element the offense is charged in cause number 2019-0D05421 and cause number 2020-0D01164 of theft of property in an amount of less than $2,500 with 2 or more previous convictions beyond a reasonable doubt. Your Honor, the defendant is pleading to 10 months in state jail confinement and other terms and condition on the state's plea paperwork, and the state will dismiss cause number 2020-0D00540. And at this time, the state moves to admit Exhibit 1 is the state's plea paperwork, Exhibit 2, Article 3914 disclosures, and Exhibit 3 is the indictment.
No objection, Your Honor.
Without objection, states 1, 2, and 3 are admitted in each case. And Ms. Bobbin, is that your understanding of the plea agreement?
Yes, Your Honor.
And Mr. Horton, is that your understanding as well?
Yes, Your Honor.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea, or your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the 1-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because these are plea bargained or negotiated cases, you do not have an automatic right of appeal. Mr. Horton, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, Your Honor.
They were signed by your attorney and signed by the court as well. So on your pleas of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. In each of these cases, I will find you guilty of the offense of theft of property in an amount less than $2,500 with 2 or more previous offenses. And I will sentence you according to the plea agreement at 10 months confinement in the Texas Department of Criminal Justice State Jail facility. Those sentences will run concurrent with one another and you will receive credit for any and all time that you have served. My understanding is, and the court is amenable to giving him credit. I have the listed dates. This was for some time that he was in federal custody. Is that right, Missy Bobbin?
That's correct, Your Honor.
I show those dates to be October 23rd, 2019 to November 4th, February 26th, 2020 to May 26th, 2020, September 21st, 2020 to December 21st, 2020, and February 11th, 2021 to February 17th, 2021. Does that conform with your notes, Missy Bobbin?
Yes, those were the dates I was provided by Ms. Pages.
Okay, perfect. Anything else?
Nothing further, Your Honor.
Thank you very much. Good luck to you, Mr. Horton.
Ms. Bobbin also has one on page 5, Judge.
Okay.
Annex, may we have Jesus Garcia?
Mr. Garcia?
Yes, ma'am.
Okay, go ahead.
In cause number 2019-0D0-5097, State of Texas versus Jesus Lorenzo Garcia. Announcement of council, please.
Okay, for the state of Texas.
Deborah Bobbin, covering for Myrna Pages. Ready, Your Honor.
And Mr. Garcia is appearing from the jail annex. We're scheduled, I just have it down for a status conference. Is that right?
Yes, Your Honor.
Okay. What are we doing with Mr. Garcia's case?
Judge, I believe he had been on our unable to locate caseload, but he's back in jail. And I think we need basically a new.
Oh, I see. It took a second for Odyssey to, yes, I have a notation that he was an absconder. We had a final hearing plea deadline last in May. And so Myrna, let's get him a trial date, December 2nd, and then we'll have our settings leading up to that. Any new cases? I see there's an OC, any
Yes.
potential felonies?
Oh, well, I can't speak for the state. I just know that there's a new filed failure to ID in CCR1.
I see that one. All right, well, we'll get you a trial track set up. If there's anything that requires a hearing outside of our regular dates, please request it via email with your attached pleading. If you want me to look at anything on the bond, you're free to file your motion and we can set it for a hearing.
Understood. Ms. King, do we have an offer at this point? I know the last rec was like years ago.
No, not at this point.
Let me look. Adolfo, is this one that we had a PSR on? I don't think I would have requested it.
I believe I did run it, Judge.
Yeah? Let me see.
Yes, I did, Judge.
Oh, you did, okay. Let me just look. Yeah, based on the PSR stuff, the last thing was the failure to ID in our case. So I'm not seeing anything else unless, let me see, New Mexico. 2012, nope. Nothing's coming up on the PSR, just FYI. Okie dokie. All right, so we'll get you your settings. Thank you very much, Missy Bobbin. Thank you, Mr. Garcia.
Thank you, Judge. Yeah.
Thank you, Judge.
Done. Anyone else? Mr. Stevens is here. Mr. Stevens, thank you, Missy Bobbin. If you're done, you're good to go.
Thank you.
Sure.
And next, may we have David Munoz?
Yes, sir.
Page 8, Judge.
Okay. Is this our last one?
I believe so, Judge.
Mhm. Okay, go ahead.
And cause number 2021-0D01363, State of Texas versus David Munoz. Announcement of council, please.
Roa King for the state of Texas.
Brent Stevens for Mr. Munoz.
And Mr. Munoz is appearing from the jail annex. We're scheduled for a probation status hearing. I just had the reports up. Let me see, David. Okay. All right, Miss Carla, we haven't seen enough of you today. So why don't you tell me about that case summary?
Your Honor, we were just, okay, so last hearing in May, we were discussing whether we were gonna just do the rebel, a state jail rebel. The plea of true, or probation's recommendation was for Mr. Munoz to attend the 90-day inpatient treatment with Casa Vida. But I understand through Mr. Stevens that he had an employment and everything, and that was the only issue, that Casa Vida does not allow them to leave for work purposes. But other than that, Judge, Mr. Munoz was just placed on probation in February of this year. A month later, he got rearrested for 2 different charges, and he's been in custody.
I remember Mr. Munoz. He called before, I think we had some type of status, and he turned himself in. I remember.
Yes, the bench warrant.
And he has, without looking, doesn't he have an extensive criminal history? Yeah. Mr. Stevens?
Well, I was hoping for a quick resolution on this case. I don't think so, but maybe we can. I had originally hoped we could just do a 1244A with like 270 or 300 days in jail. The theft case was a dog collar and a can of beers, but he does have a long history of this sort of thing. That's the problem. But on the other hand, David has made great strides in his life. I mean, he really has. And he has rid himself of having a drug problem. He was still having alcohol problems. But he's been in jail now for 90 days. We'd like to just do some sort of rebel and send him on his way. The other case still hasn't even been filed, which is a misdemeanor. We're waiting on that.
What's
He's
the
not
other
being held
case?
for that. That's the case where he was living in an abandoned property and is charged with criminal trespass. It's not really even a habitation. It was a former business, I think. So it's a criminal trespass. So we're waiting on that case to be filed or even presented, I think.
Can you do 180 and let's be done with it on the Revo, the state jail?
I'll talk to him about that, Judge, if that's the best offer that's available. He's got about 90 days credit right now.
I am going to set this down for 30 days probation status hearing. That's where I am. I remember his extensive history. At the end of the day, it's just a matter of just doing his time for it. And I'm not gonna, overdo it in the sense that I think some of his time has it been more than that? Like when he's gone, hasn't he? He's had pen trips before, or let me see. Let me go back and look at him.
There's quite a bit of history there. I'm not gonna sugarcoat it.
Yeah, I get it. To me, it bodes well that he did. I remember when he called in, I want to say it was back in February or March. He was straightforward. He made his case there, but it was just, he allegedly reoffended and he turned himself in, I think, right? So I'm at 180. We can do that before 30 days if he's in agreement. If not, I'll see you in 30 days.
All right, Judge, I'm going to visit with David and ask him what he wants to do. And he still at 180, he's still got quite a bit of time left to do on that sentence. So I'm going to be out for about a week right before July 4th. So anytime other than that, I can do it.
Sure. Yeah, no, we'll come back. Actually, we're not going to do 30 days. We're going to have to put it for, let's put it for the the 26th of July, Myrna, at 3 p.m. probation status.
All right, we'll either have our paperwork signed before then, or we'll ask for a rebel.
Okay, sounds good. Thank you.
All right, thank you.
Annex, I think